For nearly 2 decades, on the outskirts of St. Petersburg, there stood an enormous complex of buildings known as Bethel. This wasn't just any religious facility. It was the national headquarters of Jehovah's Witnesses in Russia. Hundreds of volunteers lived there. Entire families dedicated their lives to religious service within those walls. It was a self-sufficient center, complete with dormitories, administrative offices, industrial kitchens, printing facilities, and distribution centers. It was a place that symbolized stability, commitment, and faith. But in 2017, this religious sanctuary would become the epicenter of one of the most unlikely legal battles in modern history. A battle that began in Moscow, moved to the European Court of Human Rights, and ultimately ended in the federal courts of the United States. The result? A verdict that practically sealed the fate of the property and demonstrated how sometimes, not even contracts, not even taxes paid for years, not even international tribunals can recover what a sovereign state decides to take. Part 1. What was the St. Petersburg Bethel? Let's start at the beginning, with Bethel itself. When we talk about the St. Petersburg Bethel, we're not talking about a small chapel or a modest meeting hall. We're talking about a massive complex. A place where more than 300 volunteers, known as Bethelites, lived and worked every single day. These weren't part-time volunteers. These were people who had committed their entire lives to this work. Young people, older couples, families with decades of service. From this complex, the entire structure of the religion in Russia was administered. Biblical translations happened here. Literature was printed here. National communication was coordinated here. Logistics, missionary training, administrative work. Everything that kept Jehovah's Witnesses functioning across the vast Russian territory flowed through these buildings. Now, here's where the legal foundation becomes important. Between the years 2000 and 2010, several donation contracts were signed. These weren't informal agreements. These were legal documents that transferred ownership of the buildings from local Russian entities to the Watchtower Bible and Tract Society, the legal entity connected to Jehovah's Witnesses in the United States. This is standard practice for the organization, which centralizes property ownership under its American headquarters. And these contracts, they were accepted by the Russian government at the time. There was no dispute, no legal challenge, no question about their validity. The transfers went through official channels. They were registered. They were recognized. According to the organization, over the next 17 years, the Watchtower paid more than 172 million rubles in property taxes on the Bethel complex. That's not an insignificant amount. It's the kind of sum that reinforces legitimate ownership. When you're paying taxes year after year, decade after decade, it sends a clear message. This property is legally ours, and we're fulfilling all our obligations as owners. For 17 years, nothing indicated any conflict. The Bethel operated normally. Volunteers came and went. Literature was produced. The work continued. Everything seemed stable, legitimate, and secure. Until 2017. April 2017 marked a watershed moment, not just for Jehovah's Witnesses in Russia, but for religious freedom cases worldwide. The Supreme Court of the Russian Federation made a radical decision. They declared Jehovah's Witnesses an extremist organization. With that single classification, they ordered the liquidation of all their legal entities and banned their activities throughout the entire Russian territory. Now, let's be clear about what this meant. This wasn't a restriction. This wasn't a warning. This was a complete ban. Overnight, practicing the religion became illegal. Gathering for worship became illegal. Distributing literature became illegal. Everything that Jehovah's Witnesses had been doing openly and legally for decades was suddenly classified as extremism. And with that single court decision, all religious centers, including the massive Bethel complex in St. Petersburg, became properties subject to confiscation by the state. The reasoning? The Russian authorities argued that the religious teachings and practices of Jehovah's Witnesses constituted extremism, that their literature incited hatred, that their practices undermined social harmony. Legal experts and human rights organizations around the world questioned these claims, but within Russia, the decision was final. And the consequences were immediate. Within weeks of the Supreme Court decision, Russian authorities moved against the Bethel. Imagine the scene. Hundreds of volunteers who had made this place their home, their life's work, suddenly facing eviction. Security forces arriving. Officials conducting inventories. Legal notices being served. The entire complex, with all its facilities, equipment, and infrastructure, was seized by the Russian state. But here's where the legal maneuvering becomes particularly interesting. Remember those donation contracts from 2000 to 2010? The ones that had been accepted and registered by Russian authorities? The ones that had formed the legal basis for Watchtower's ownership for nearly 2 decades? They were suddenly declared invalid. Russian courts retroactively annulled them. The argument was straightforward, at least from the state's perspective. These transfers were never legitimate. They were, according to the courts, fictitious transactions. A legal sleight of hand designed to hide assets belonging to what was now classified as an extremist organization. Never mind that these same transactions had been officially recognized for years. Never mind the taxes paid. Never mind the legal registration. With the stroke of a judicial pen, they became void. The Bethel was now state property. But the story doesn't end with the confiscation. Years later, the complex was officially transferred to a new owner. The National Medical Research Center named after V.A. Almazov, an institution under the Russian Ministry of Health. What had once been a center of religious activity, where hundreds of people lived and worked in service of their faith, was now a medical research facility owned and operated by the Russian government. For the Watchtower, this meant losing, literally overnight, a multimillion-dollar property. Decades of investment, development, and use wiped away. Faced with this situation, the Watchtower did what many organizations do when they believe their rights have been violated by a state. They went to an international tribunal. They filed a case with the European Court of Human Rights, the ECHR. This court, based in Strasbourg, France, has jurisdiction over human rights violations in countries that have signed the European Convention on Human Rights. Russia, at the time the case was filed, was still technically bound by the court's decisions. The Watchtower argued that the confiscation violated their right to peaceful enjoyment of possessions, protected under Protocol 1, Article 1 of the Convention. They argued that the ban on their religious activities violated freedom of religion. They argued that the entire process was a fundamental violation of their rights under international law. And remarkably, they won. The European Court of Human Rights ruled in favor of the Watchtower. The court found that Russia had indeed violated the organization's rights. The confiscation was ruled unlawful under international law. The ban itself was found to be disproportionate and unjustified. The court issued an order. Russia must either return the Bethel complex or, according to the Watchtower, pay compensation in the amount of 38,243,874 euros. It was a significant victory. A major international human rights court had validated their claims, had confirmed that their rights had been violated, had ordered remediation. The victory lasted exactly 1 day. On the same day the European Court's decision was announced, Russia made its own announcement. The Russian government declared that it no longer recognized the authority of the European Court of Human Rights. It would not comply with any of its decisions, past or future. It was withdrawing from the jurisdiction of the court entirely. In practical terms, the ECHR's ruling became nothing more than a symbolic gesture. A moral victory, perhaps, but legally unenforceable. There was no mechanism to compel Russia to comply. No way to force them to return the property or pay compensation. The decision existed on paper, but had no real-world effect. The Watchtower had won in court but lost in reality. Without viable options in Europe and with zero chance of recovery within Russia itself, the Watchtower made a bold strategic decision. They would take the fight to their home turf. They would sue the Russian Federation in the United States, where the Watchtower is headquartered. In 2024, they filed a lawsuit in federal court in Washington, D.C. The complaint was comprehensive. It accused the Russian Federation of expropriation, trespass, unjust enrichment, and conspiracy. The organization sought full compensation for the value of the complex. Now, if you're not a legal expert, this might seem like a reasonable next step. After all, the Watchtower is an American organization. They have standing in American courts. Why not pursue the case here? But there was a fundamental problem with this strategy. A problem so significant that it would ultimately doom the entire case. And that problem has a name: sovereign immunity. The case landed on the desk of a federal judge. And almost immediately, the most obvious legal barrier appeared. It's called the Foreign Sovereign Immunities Act, known by its acronym, FSIA. This is a federal law passed in 1976 that governs when and how foreign countries can be sued in United States courts. The default rule is simple. Foreign sovereign states are generally immune from lawsuits in U.S. courts. This isn't some obscure technicality. It's a fundamental principle of international law and diplomatic relations. Countries don't sue each other in domestic courts. It would create chaos in international relations if every dispute could be dragged into the court system of one of the parties involved. The FSIA does provide exceptions. Very specific exceptions. For example, if a foreign state engages in commercial activity in the United States, it might be subject to suit. If a foreign state causes injury or death in the United States through certain actions, there might be jurisdiction. If a foreign state takes property in violation of international law, and that property has a commercial connection to the United States, there might be an opening. The Watchtower's lawyers tried to argue that their case fit within these exceptions. They argued that the Bethel property had a sufficient connection to the United States because it was owned by an American organization. They argued that the taking violated international law, as confirmed by the European Court. But the judge was skeptical from the start. In his initial assessment, he noted the obvious: foreign states are generally immune from suit in United States courts. That single sentence captured the fundamental problem. The Watchtower wasn't suing a corporation or an individual. They were suing a sovereign nation. And sovereign nations have protections that ordinary defendants don't have. But even if the judge could be convinced that an exception applied, there was another problem. An even more insurmountable one. Here's something most people don't think about when they imagine international lawsuits. How do you actually notify the defendant that they're being sued? In the American legal system, there's a fundamental requirement called service of process. It means you have to formally deliver the legal documents to the defendant. They have to receive actual notice that a case has been filed against them. Without proper service, the court has no jurisdiction. The case simply can't proceed. When you're suing an individual or a company within the United States, this is usually straightforward. You hire a process server. They hand the documents to the defendant or leave them at their residence. Done. But when you're suing a foreign country, the process is governed by international treaties and diplomatic protocols. You can't just hire someone to walk up to the Kremlin and hand papers to a security guard. For Russia, the proper method involves official channels. The documents must be sent through diplomatic channels or by registered mail to the Russian Ministry of Justice. Russia must receive and acknowledge the documents according to the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents. And here's where everything falls apart. Russia refuses to accept service of legal documents from foreign courts seeking to establish jurisdiction over the Russian government. It's an official policy. They simply won't accept the papers. But it gets worse. Even if you could somehow get around the official refusal, there's a practical problem. International shipping services that might normally be used for important documents have stopped serving Russia for legal purposes. Companies like DHL, UPS, and FedEx stopped delivering legal documents to Russia after the invasion of Ukraine. The geopolitical tensions, the sanctions, the complexities of international law during wartime, all of it combined to make normal shipping channels unreliable or completely unavailable. The Russian government doesn't accept service through ordinary mail from foreign countries. International courier services won't deliver. And diplomatic channels are closed to private lawsuits of this nature. The result? There was simply no way to serve the lawsuit on Russia. And without service, there is no case. It's not a minor procedural issue. It's a fundamental requirement. If the defendant doesn't receive notice, the entire proceeding is invalid. The Watchtower tried various arguments. They tried to show that Russia had sufficient notice through other means. They pointed out that Russia obviously knew about the case. That Russian officials had been quoted in news stories about it. That surely, in the modern age of instant communication, formal service was a technicality. The judge disagreed. The rules exist for a reason. They protect defendants from surprise lawsuits. They ensure fairness. They maintain the integrity of the judicial system. And they couldn't simply be waived because service proved difficult or inconvenient. In September 2025, the federal judge issued his final ruling. The case was dismissed. Not on the merits, meaning the judge didn't even reach the question of whether Russia had acted wrongfully. It was dismissed on jurisdictional grounds. The fundamental requirements for the court to even hear the case weren't met. The court accepted Russia's arguments and those of the Ministry of Health, which had been named as a co-defendant because it now controlled the property. The ruling was clear. There was no jurisdiction over a foreign sovereign state. There was no valid service of process. There was no way to overcome sovereign immunity under these circumstances. The judge didn't express an opinion on whether Russia had acted properly or improperly in confiscating the property. He didn't address whether the European court had been correct in its ruling. He didn't evaluate the underlying merits of the case at all. He simply determined that an American federal court was not the proper forum for this dispute, that the barriers to proceeding were insurmountable, that the case could not continue. With that ruling, the case ended. Not with a bang, but with a technical dismissal. Russia remains in control of the former Bethel complex. The National Medical Research Center named after V.A. Almazov continues to operate from those buildings. And the watchtower was left with no practical legal options remaining. Oh, what does this case really tell us? What can we learn from this unlikely journey through international law, sovereign immunity, and the limits of legal recourse? At its core, this case exposes an uncomfortable truth about international law and property rights. When a sovereign state decides to take property within its own territory, there is remarkably little that can be done to stop it or to obtain meaningful recourse. Think about what the watchtower had going for them. They had legal contracts that had been accepted and recognized by Russian authorities for years. According to their own accounting, they had paid more than 172 million rubles in property taxes over 17 years, continuously reinforcing the legitimacy of their ownership. They had international recognition of their rights. They had a favorable decision from the European Court of Human Rights, one of the most respected international tribunals in the world. And none of it mattered. None of it was enough to recover the property or obtain compensation. The case reveals something fundamental about the nature of sovereignty and the limitations of international law. In theory, international law provides rules that govern how nations should behave. Treaties establish norms. International courts can issue judgments. But at the end of the day, enforcement depends on voluntary compliance or the ability to exert meaningful pressure. When a major power like Russia decides it will not comply with an international court ruling, there's no international police force that can compel compliance. There's no higher authority that can force a sovereign nation to return property or pay compensation. Economic sanctions might be imposed, but those are political decisions, not legal remedies. And they may or may not have any effect on the specific dispute at hand. The sovereign immunity doctrine, which blocked the lawsuit in the United States, reflects this reality. It acknowledges that nations must have protection from being sued in each other's domestic courts. Otherwise, international relations would become impossibly complicated. Every dispute, every disagreement, every perceived injustice could potentially be litigated in multiple domestic court systems around the world. It would be chaos. But that protection comes at a cost. It means that when a sovereign state takes action within its own borders, even action that violates international law, the options for legal recourse are extremely limited. The watchtower pursued every avenue available to them. They went to the Russian courts. They went to the European Court of Human Rights. They went to American Federal Court. At each step, they encountered barriers. Legal barriers, procedural barriers, practical barriers. The case also highlights the reality of geopolitical tensions and how they affect even basic legal processes. The inability to serve documents on Russia wasn't just a technical inconvenience. It was a reflection of the broader breakdown in relations between Russia and Western countries. The war in Ukraine, the sanctions, the diplomatic tensions, all of it created an environment where even routine legal procedures became impossible. This case doesn't exist in a vacuum. It's part of a larger pattern of religious persecution in Russia, particularly targeting groups that Russia classifies as non-traditional religions. Since the extremism designation in 2017, Thousands of Jehovah's Witnesses in Russia have been subjected to police raids, arrests, prosecutions, and imprisonment. Ordinary people, guilty of nothing more than practicing their faith, have been labeled extremists and criminals. Their homes have been searched. Their meetings have been disrupted. Their religious materials have been confiscated. The confiscation of Bethel was just the most visible, most valuable target in a much broader campaign. But it's symbolically significant. When a state can simply take the national headquarters of a religious organization, declare it state property, and repurpose it for government use, it sends a powerful message about the limits of religious freedom and property rights. The case also raises questions about the effectiveness of international human rights mechanisms. The European Court of Human Rights ruled in favor of the Watchtower. It found that Russia had violated international law. It ordered remediation. But when Russia simply ignored the ruling and withdrew from the court's jurisdiction, the decision became meaningless in practical terms. What's the point of international courts if their rulings can be ignored without consequence? This isn't just an academic question. It goes to the heart of whether international law has any real force when dealing with powerful states that choose not to comply. Some would argue that international law still has value even when enforcement is difficult. It establishes norms. It provides moral authority. It creates a historical record of what was right and what was wrong. Even if Russia doesn't comply now, the European Court's ruling stands as a judgment that can be pointed to in the future. Others would argue that unenforced rulings actually undermine international law by demonstrating its weakness. If major powers can simply ignore international courts without meaningful consequences, it encourages others to do the same. It makes the entire system of international justice appear toothless. There's truth in both perspectives. But for the Watchtower, and for the hundreds of volunteers who lost their home at Bethel, the philosophical debates about international law provide little comfort. It's natural to ask, could the Watchtower have done anything differently? Was there a legal strategy that might have worked? In retrospect, it's difficult to see what other options were available. Once Russia classified Jehovah's Witnesses as extremist and began confiscating property, the legal paths forward were always going to be limited. The European court case was the strongest option, and they won it. But winning isn't enough when there's no enforcement mechanism and the defendant simply refuses to comply. The American lawsuit was a creative attempt to find another forum, but sovereign immunity was always going to be a nearly insurmountable barrier. The Watchtower's lawyers certainly knew this going in. They must have understood the challenges. But when you've exhausted all other options, even a long-shot legal strategy might seem worth pursuing. Some might ask, couldn't political pressure have been applied? Couldn't the U.S. government have intervened on behalf of an American organization? In theory, yes. The U.S. government could have raised the issue through diplomatic channels. It could have made the confiscation part of broader negotiations with Russia. But in practice, the relationship between the United States and Russia has been so strained, particularly after the invasion of Ukraine, that diplomatic intervention on behalf of a private religious organization was unlikely to gain traction. Moreover, the U.S. government typically doesn't intervene in private legal disputes, even when American citizens or organizations are involved. There are exceptions, particularly in cases involving hostages or criminal prosecution, but a property dispute, even a large one, wouldn't normally trigger direct government intervention. The hard truth is that once a sovereign state decides to confiscate property within its borders, and once that state is willing to ignore international courts and face whatever diplomatic consequences might follow, there's very little that can practically be done. Throughout this legal saga, it's easy to focus on the jurisdictional issues, the procedural battles, the sovereign immunity doctrine. But we shouldn't lose sight of the human element. For hundreds of Bethelites, the St. Petersburg complex wasn't just a piece of real estate. It was their home. Many of them had lived there for years, some for decades. They had dedicated their lives to the work that took place in those buildings. They had formed deep friendships with fellow volunteers. They had routine and purpose and community. The confiscation didn't just mean the loss of property. It meant displacement. It meant uncertainty about the future. It meant watching as a place that held deep personal and spiritual significance was taken by force and converted to an entirely different use. For older Bethelites who had spent perhaps 20 or 30 years in service at the complex, the loss must have been particularly profound. Imagine building your entire adult life around a place and a mission, only to see it dismantled in a matter of weeks. Many of these volunteers faced not just displacement but also persecution. Remember, Jehovah's Witnesses weren't just banned from the Bethel. Their entire religion was banned throughout Russia. Practicing their faith became illegal. Many faced the choice between abandoning their beliefs or facing criminal prosecution. Thousands did face prosecution. Police raids became common. Homes were searched. Religious materials were seized as evidence of extremism. People were arrested, tried, and in many cases, imprisoned. Not for violence. Not for actually promoting hatred or extremism in any meaningful sense, but simply for continuing to practice their faith. The Bethel case, for all its legal complexity, is ultimately about people whose lives were upended by a government decision to classify their peaceful religious practice as extremism. So where does this leave us? The legal battle is over. The case has been dismissed. Russia controls the former Bethel. The Watchtower has no remaining legal avenues within the existing international system. But the broader questions remain unresolved. Questions about religious freedom, about property rights, about the limits of sovereignty, about the effectiveness of international law. The Bethel case serves as a stark reminder that in the modern world, for all our international institutions and legal frameworks, power still matters more than law in many situations. When a major state decides to act, and is willing to accept the diplomatic and reputational consequences, there are real limits to what legal mechanisms can accomplish. It's an uncomfortable conclusion. We want to believe that legal rights are protected, that international law matters, that justice can be obtained through proper channels. And often that's true. But this case shows the exceptions. It shows what happens when legal rights collide with sovereign power and geopolitical realities. For Jehovah's Witnesses in Russia, the fight continues, not in courtrooms but in their daily lives. They continue to practice their faith quietly, despite the ban. They face ongoing persecution. They support each other through arrests and trials. The loss of Bethel was devastating, but the community continues. For the Watchtower organization, the legal defeat in 2025 represented the closing of a chapter. They fought the case as far as they could. They won in the European court. They tried again in American federal court. Both victories and defeats are now part of the historical record. But the complex itself stands as a monument to an uncomfortable truth. That when a state decides to take something, backed by its own courts and its own definition of national security, recovering it through legal means may simply be impossible. The question that opened this documentary remains. If neither an international tribunal nor the United States government can recover a confiscated complex, who could? The answer, it seems, is no one. And that might be the most important lesson of the entire Bethel case.